CRPA lawsuits are now helping Californians in unconventional ways, as we now have a press release from the Federal Department of Justice and Pam Bondi taking aim at Los Angeles County for long wait times and high fees for CCWs. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, CRPA litigation is working on the federal level for the betterment of California. To talk about it today, we have brought back our volunteer president of CRPA, that is Michel. Chuck, thanks for being with us today.
Always a pleasure, fellas.
Absolutely. But before we get into that today, guys, please be sure to like, share, and subscribe to these videos. It really helps get the information out there as far and wide as possible. The ball is rolling in the right direction, and we want to make sure that it keeps moving that way. The only way that we can do that is to make sure that everybody's informed. So once again, please be sure to like, share, and subscribe. It really helps with the algorithms on these videos. So let's jump right into this today. Chuck, we've got this press release from the Department of Justice, Office of Public Affairs. I want to read the whole thing. It's a little bit much, just so that everybody has the correct context on this as opposed to paraphrasing. Jacob, if you could pull it up, it reads like this. Protecting the Second Amendment rights of ordinary law-abiding Americans is a high priority for this administration. As part of a broader review of restrictive firearms-related laws in California and other states, the Department of Justice's Civil Rights Division today announced an investigation into the Los Angeles County Sheriff's Department to determine whether it is engaging in a pattern or practice of depriving ordinary law-abiding Californians of their Second Amendment rights. A recent federal court decision found that the law and facts were clearly in favor of two private plaintiffs who challenged the lengthy 18-month delays that the Los Angeles County Sheriff's Department had imposed when processing their concealed handgun license applications. Yes, you guys, that is the CRPA lawsuit, CRPA versus the Los Angeles County Sheriff's Department. And the Civil Rights Division has reason to believe that those two plaintiffs are not the only residents of Los Angeles County experiencing similarly long delays that are unduly burdening or effectively denying the Second Amendment rights of the people of Los Angeles. The Supreme Court has repeatedly recognized that the Second Amendment is not a second-class right, and over the past 2 decades, the Supreme Court has recognized that the Second Amendment is a fundamental individual constitutional right and has taken multiple opportunities to strengthen Second Amendment protections for ordinary law-abiding citizens. Some states and localities, however, have resisted this recent pro-Second Amendment case law, and California has been a particularly egregious offender. In response to the recent Supreme Court case law, California enacted new legislation to further restrict the ability of ordinary law-abiding Californians to keep and bear arms. Case in point, Senate Bill 2 right there with our sensitive places restrictions, and many California localities appear to be imposing additional burdens beyond those required by California state law, including by subjecting ordinary law-abiding Californians to extensive fees and lengthy wait times associated with applications for concealed handgun licenses. This Department of Justice will not stand idly by while states and localities infringe on Second Amendment rights of ordinary law-abiding Americans, said Attorney General Pam Bondi. The Second Amendment is not a second-class right, and under my watch, the department will actively enforce the Second Amendment just like it actively enforces other fundamental constitutional rights. Attorney General Bondi hopes the states and localities will voluntarily embrace their duties to protect the Second Amendment rights of their citizens, but if necessary, today's announcement will be the first of many similar investigations, lawsuits, and other actions involving other localities in California, the state of California itself, and any other states or localities that insist on unduly burdening or effectively denying the Second Amendment rights of their ordinary law-abiding citizens. Okay, so we've got all that, and it sounds great. You know, we've got the federal administration behind us. That's what we voted for, so that's what we expect, and it all sounds good. Chuck, when reading this, I'm really curious. I hope. They're certainly exciting for me to read. I'm assuming it's the same on your end. What's the action to follow potentially that you see when reading a press release like this?
Well, the United States Department of Justice does these pattern or practice investigations into police departments when they think they're up to something no good. A lot of times it's chronic police brutality or racism or some kind of a corrupt practice in a police department that the United States government wants to look into. This all came about because of the CRPA's lawsuit, and that CRPA lawsuit came about because of the CRPA's CCW Reckoning Project, which is ever since Bruin came down, ever since the Bruin decision came down in 2022, we have been communicating with pretty much every city and county in the state, telling them what their obligations are under Bruin. They have to get rid of this baloney good cause requirement that haunted us for years as it was subjectively interpreted and used to deny people CCWs. Many jurisdictions changed their practices once we educated them about what their obligations were. Some didn't, and some insisted on not allocating the resources necessary to timely process applications or charging too much for an application. So the CRPA finally sued the County of Los Angeles and the Los Angeles County Sheriff's Department and the City of Laverne over their wait times and high fees. City of Laverne has now lowered their fees. County of Los Angeles is working, they say they're working on shortening up their wait times. In the meantime, though, while we were litigating those cases, President Trump ordered Attorney General Bondi to sort of survey the landscape nationally of what was going on with Second Amendment litigation, Second Amendment policy, Second Amendment issues. And a number of groups submitted materials to the Attorney General's office, including CRPA. So we sent in an entire sort of a brief, a summary of all the things that the CRPA's CCW Reckoning Project had discovered, including mentioning that we had this lawsuit against the County of Los Angeles and that there were these results where the judge had found that they were taking too long and charging too much. And the DOJ picked up on that. The lawyers at the DOJ picked up on that and got the information about our case, which is all posted online, and decided to take some action on their own because the County of Los Angeles is still trying to fight us on that case, although they may capitulate, and they may try and make it so it only applies to CRPA members or it only applies to the two individually named plaintiffs. And the United States, the Department of Justice getting involved means they have to change their pattern or practice. The department does, the Sheriff's Department does, for everybody, and that's what we need. Meantime, LAPD is still taking too long, and they've got a demand letter, pre-litigation demand letter from CRPA. And the County of Santa Clara is charging too much. They got a pre-litigation demand letter from CRPA. So we will sue those jurisdictions next unless they change their practices. And we will be, of course, letting the DOJ know that those two jurisdictions are also dragging their feet and trying to make it harder for people to get a license to carry in public, to which they are constitutionally entitled.
Could you there are several kind of patterns and practices that you could identify here. Some of them having to do with the courts, others having to do with the county like Los Angeles. What are the patterns and practice that you see here that need to be changed? And the reason why I ask is because we're starting to see this on some lawsuits now. You have judges who want to grant for the plaintiffs only when the unconstitutionality of a law affects everybody. Any chance that we could get a change in pattern or practice there?
No, you have to separate. There's what the courts do, and then there's what the police department, the county sheriff does. The DOJ is not investigating what the courts do. That's a separate issue, which there should be some looking into that. But that's something that's not related to the pattern or practice of the County of Los Angeles and how they issue or don't issue and what they charge for CCWs. The only pattern or practice that the US DOJ is focusing on now is the LA County Sheriff and what they're doing or not doing. And what they're doing is, or not doing, is processing applications fast enough because they haven't devoted the resources necessary to and put the manpower in place to process the applications fast enough. And that's what they said in response to this DOJ press release, that we're backlogged. Well, we didn't create the system. The government created the system. And I would say in many instances, they intentionally created it so that it would be cumbersome and hard to issue CCWs, and that they would be less, worth less because they designated all these places as sensitive. And so some jurisdictions are intentionally, I think, dragging their feet. LA County Sheriff swears it's not. Well, okay. Uh, all we care is you got to process those applications faster. And if that means you got to allocate more resources to do it, then that's what you got to do. And if you don't like the system, then go up to Sacramento and tell the politicians to streamline the system so it doesn't take so long. But otherwise, it's not our problem. It's not the problem of the gun owners that the California legislature created a system that it takes too long for local issuing agencies to comply with. They have to throw as much money at it as it takes to get it done on time.
Yeah, especially if they're going to be the ones creating the system. Jacob, if you could actually pull this up, I want to focus on the last paragraph of this press release for a second. It says, Attorney General Bondi hopes that the states and localities will voluntarily embrace their duty to protect the Second Amendment rights for their citizens, but if necessary, today's announcement will be the first of many similar investigations, lawsuits, or other actions involving other localities in California. It's kind of implying here that lawsuits may be to follow. My question to you is, how is this going to be different than what we're already doing? I mean, minus the investigation part, because we don't really need to investigate anything. We're Californians. We're living under this tyranny.
They want the details. Our investigation, quote unquote, comes through the form of discovery. It's the factual exchanges that take place in a lawsuit. So we're going to, when we sued the LA County, we wanted to know, how many people do you have in your department working on this? How long does it take? How many applications have you had? What's the average wait time? All the details about how their system works or doesn't work. That's what we're kind of limited to in CRPA's lawsuits. Now, the DOJ, they can go anywhere with their investigation. They can go ask the county board of supervisors, how come you're not allocating enough money? They have a much broader authority and a much bigger mandate to look into all the games that are being played, not just by the LA County Sheriff, but by anybody that's trying to influence the LA County Sheriff in the way they do or don't issue these permits. So having the DOJ involved, it's, CRPA is working miracles, but when the United States government gets involved, cities listen. And so I've already put out a warning to LAPD and Santa Clara that they're next, and and there'll be others behind them. Any city that tries to charge too much for an application process, and any city that takes too long is in our sights. So we're hopeful that this will send a message to those cities to get their act together and bring themselves in compliance so that we don't have to sue every single one of them. But we will if we need to, as long as people support us and give us the tools that we need to bring those suits. We just need the funding. We have multiple lawsuits going on right now, and we're making CRPA is making a huge difference. CCW is where the sort of the battleground is, the sort of the boots on the ground fight is right now. There's sexy lawsuits like semi-auto bans and the magazine capacity limitation lawsuit and the ammo background check lawsuit. We have a dozen, and all those other lawsuits are very much in play. But the one that I guess the two that people feel most directly is the semi-automatic rifle that they want to buy and the CCW that they want to get so they can carry and defend themselves and their families in public. And then there's our Bolin lawsuit so that we can open up the market for handguns that you can buy in California as well. So we've got a full plate. And so when the U.S. Department of Justice gets involved and can take some of this weight off us and throw a little more weight of their own on top, it's a great thing. It's a good day.
Yeah, and really where I was going with that was to ask, like, it is good, and I can understand that to get the DOJ involved in this way. What are the mechanisms of enforcement that the DOJ has? You kind of alluded to them being able to go outside the scope of what a CRPA lawsuit might be by going to the Board of Supervisors or something like that. But what is the actual mechanism of enforcement that they have for these sentiments?
U.S. DOJ, look, first they'll negotiate. First they'll figure out, what exactly is happening here and why can't you get this done? And why does it cost so much? They will now learn all about the CCW application processing system and who's influencing it. And then they will probably have discussions with the County of Los Angeles about voluntarily coming into compliance. If they can't satisfy the US DOJ, then the DOJ files a lawsuit in federal court forcing a local jurisdiction, LA County Sheriff, to comply with the law. And then they get a consent decree. In other words, DOJ just doesn't get a judgment. They get an ongoing monitoring of a department to make sure that they come into compliance and then stay in compliance. And that's what cities hate, to be under this consent decree from the federal government, where they have to report and make sure that they are doing everything right and satisfy the federal government that they're not playing games. They're constantly being looked at. The review goes on indefinitely until the parties agree that they can let it go. So that's their enforcement mechanism. Ultimately, it's a consent decree, which is basically a court judgment that says the LA County Sheriff has to do things a certain way.
So would that end up being filed in a California federal court, or potentially going to the Ninth Circuit?
Yes, it would be filed. Yeah, but this is not a 2A case like any other, like one being brought by the CRPA or the other groups we work with. This is the United States Department of Justice. When that kind of lawsuit gets filed, judges pay a lot more attention.
Well, hopefully so. I guess to wrap this up, and looking forward to the potential voluntary compliance of places like Los Angeles County, or that oversight that ends up being enforced if there isn't voluntary compliance. How do you see this shaping out in the near future? I mean, we've got this press release.
I think the county's going to come to us and try and settle the case. They're going to want to settle the case. They're going to want to bring themselves in compliance. They're going to go to the county supervisors and say, we need more money. The county board of supervisors is going to say, now they can't say, oh, CRPA is going to force us. They can say the United States government is going to force us. So I expect the LA County Sheriff will come into compliance. And then we will talk to the LAPD and Santa Clara and any other jurisdiction and use the LA County Sheriff resolution as a model for making other counties and cities come in line.
Well, I'm glad you call this the CCW Reckoning Campaign, because that certainly seems to be how it's playing out. There is a reckoning going on with these places that don't want to be in compliance with the Bruin decision already. Chuck, I know you're a busy guy. I want to thank you for coming on today and sharing this insight with us.
Always a pleasure, guys. This is great news. Folks, if you can support the CRPA and our efforts on this case and all the others, you'll be a part of history. It's a historic time for the Second Amendment. So.
Indeed, and we are going to continue and follow along as that history is made. Thank you again, Chuck, for coming on. And guys, if you like this kind of content, you want to continue to see it, you want to continue to see the ball moving in the right direction for your Second Amendment rights in California, please be sure to like, share, and subscribe to these videos. It's also a great way for you to directly contribute to causes like the litigative and legislative 2A efforts that CRPA puts forth every day. Thanks again, guys. We'll see you on the next one.